Imagine winning a case against a government agency and still not getting paid. For decades, Nigerians who fought hard and won in court against ministries, departments, and government bodies have faced one final, frustrating barrier: the Attorney General's consent. Under Section 84 of the Sheriffs and Civil Process Act, no judgment debt can be paid by the government without that consent. But what happens when that power, meant to regulate, becomes a tool for delay and control? In a bold 2025 Supreme Court case, Central Bank of Nigeria versus Ochife and others, Justice Helen Ogunwumiju stood up to challenge the status quo. She asked, can the Attorney General really stand between citizens and justice? Her answer shook the legal community and reopened the debate on executive power, judicial independence, and constitutional supremacy in Nigeria. Stay with us as we unpack this landmark judgment and what it could mean for every Nigerian owed money by a government institution. Before we proceed, if you find this video helpful, don't forget to like, subscribe, and share, and tap the bell so you never miss our next legal insight. Drop your comments below and tell us what topic you'd love us to cover next. Your suggestion could be our next video. Let's look at the background, the controversial Section 84 SCPA. For years, Section 84 of the Sheriffs and Civil Process Act, SCPA, has been a stumbling block to individuals and companies trying to enforce monetary judgments against government bodies, ministries, and agencies. Under this section, before any court judgment involving payment of money by the government can be enforced, the Attorney General's consent must first be obtained. In practice, this meant that even after winning in court, judgment creditors often couldn't get paid unless the Attorney General gave approval, a process that was slow, political, and frustrating. We begin with the case before the Supreme Court in Central Bank of Nigeria versus Ochife Ors, 2025. The Supreme Court was invited to reconsider this old rule. Justice Helen M Ogunwumiju, JSC, delivered a powerful opinion challenging the constitutionality of Section 84 of the SCPA. She held that Section 84 of the Sheriffs and Civil Process Act, which makes enforcement of monetary judgments subject to the discretion of the Attorney General, is inconsistent with Sections 66B and 287 of the 1999 Constitution. Considering the reasoning, Justice Ogunwumiju reasoned that 1. Section 66B of the Constitution vests judicial powers in the courts, not the executive. 2. Section 287 mandates that all persons and authorities in Nigeria must obey and enforce decisions of the courts. 3. Therefore, allowing the Attorney General to approve or disapprove payment of court judgments amounts to giving the executive power over the judiciary, which is unconstitutional. She concluded that Section 84 of the SCPA is inconsistent with Sections 1, 3, 6, and 287 of the Constitution, and therefore null and void to the extent of its inconsistency. However, it was not a majority decision. While Justice Ogunwumiju's position was bold and progressive, it was not the majority judgment of the Supreme Court. Her reasoning stands as a strong obiter dictum, a persuasive but non-binding statement of law. This means 1. Her view may guide future reforms and judicial thinking. 2. But it does not yet overturn the existing rule under Section 84 of the SCPA. And now, the current legal position, as of 2025, until a majority of the Supreme Court or the National Assembly amends the law, the old rule still applies. 1. You still need the Attorney General's consent before enforcing monetary judgments against government entities. 2. However, lawyers and litigants can now rely on Justice Ogunwumiju's obiter as a constitutional argument in challenging Section 84, especially at appellate levels. In essence, the door to reform has been opened, but not yet walked through. What this means for you: if you have a judgment debt against a government body, federal or state, 1. You still need to apply for the Attorney General's consent, but 2. You may now challenge any unreasonable delay or refusal using the argument from CBN versus Ochife Ors, 2025. that such discretion violates constitutional supremacy and judicial independence. To conclude, the Supreme Court's decision in CBN v. Ochife Ors may not have struck down Section 84, but it sparked something bigger. Justice Ogunwumuju's powerful concurring opinion is more than a legal argument. It's a constitutional wake-up call, reminding us that no arm of government should hold justice hostage. Her words have opened the door for reform, for a Nigeria where judgments are obeyed, not negotiated. For now, you still need the Attorney General's consent to enforce judgment debts against the government, but the tide is turning and the courts are listening. At Tonik Law Partners, we stand with those seeking real enforcement of justice. Whether you're a business, individual, or professional owed money by a public institution, we'll help you navigate the process and assert your rights with precision and strategy, because justice delayed shouldn't mean justice denied. Talk to Tonik Law Partners, where the law works for you.